PCC.
I hate to tell you, but you gotta say it one more time once we get on the
Sorry.
record.
Sorry.
It was perfect. We're gonna do it again.
Good morning, Your Honor. Attorney Gregory Sheena, P74815, on behalf of the defendant who is present on the Zoom call today and consents to being on the Zoom call today, Your Honor. Today's the date and time set for a PCC.
Good morning. Mr. Hill, can you state your name, please?
Juwan Hill.
Okay, and for the people,
Edwin Silwaukee, P54828.
and this is case 2356434. The people of the state of Michigan versus Juwan Hill, who is charged with count 1 controlled substance delivery, manufactured marijuana, and also count 2 weapons, funny firearm, set for a probable cause count. Attorney Sheena, do you have discovery?
Your Honor, I do not have discovery. I was going to ask the prosecutor who I need to email or request it from.
And I'm assuming that's just because you just were appointed on, retained on the case.
That is correct, Your Honor.
Okay. Spell it out one more time for me. I'll send it.
Okay, SELWOCKI. Yes.
What's your first initial? Or does it go on there in the front?
Yeah.
You had to think about it too.
You got me out of order.
Okay, Attorney Sheena, I just sent over Mr. Silwaukee's email address to request discovery. Did you sent it to the prior attorney?
I believe so.
Okay, so it shouldn't be an issue.
Now, yes, once I have your email, I'll send it over.
Okay. I got it, Your Honor. I'll shoot him an email. I did explain to my client that we would probably be adjourning today. He's prepared to waive the 21-day rule. And we would just like to request an adjournment in order for us to obtain discovery properly, go over it, and then request another PCC date, Your Honor.
Okay, what I do allow for adjourned PCC, but I also still like the second exam date.
Of course.
Far. So the earliest I have is May 8th.
And Your Honor, is that for a PCC or an exam?
For an exam. I'm working backwards.
Judge, you're doing absolutely. Starting
Um,
at 9. I'm looking at it now.
Your Honor, can we push that back a little farther? Because I feel like 2 weeks is not going to be enough time for us to review the discovery. And I have a couple trials in the next 2 weeks as well.
What date are you looking at?
Are they just Mondays?
No.
I can do the 22nd if it's a Monday.
That's my birthday. I won't be here.
Uh-oh, happy birthday.
Thank you. Can you do that week before, any day before that week?
So I that week of the 22nd is actually works probably the best with my schedule, if we can make that happen, if that's not too far.
24th?
And that's at 8:30?
That'll be for an exam, so 9, 9:30, 10, or 10:30.
Okay, let's do the latest time, 10:30. And then is that in person?
Yes, the exams are in person.
Okay.
So PCC, give it 2 weeks from today.
That May 8th day, that will work for PCC.
And that'll be at 8:30.
Okay. Thank you so much, Your Honor.
You're welcome. So Mr. Hill, we'll be back,
Yeah.
we'll be back on the 8th of May for an adjourned PCC on Zoom at 8:30. And your in-person exam has been scheduled for May 24th at 10:30. Your attorney can give you those dates again.
Okay.
Anything else?
Nothing further, Your Honor. Thank you.
Go have a good week.
You too. Thank you.
Any other attorneys ready for their case to be called?
I'm ready, Judge. I'm here on Marvin Geary. I'll be waiving his presence with the court's permission.
Okay. One second, attorney.
I got one. Yeah, just. Sorry.
Look anyway, his
Just
presence.
on it.
He said, that's fine. Thank you.
Hmm,
Okay,
Is
let's
he-
handle Marvin Geary, 23547, people state Michigan versus Marvin Geary.
Thank
Charged with count 1, weapons, firearms, possession by a felon, count 2, weapons, felony firearm, count 3, weapons, ammunition, possession by a felon, count 4, weapons, felony firearm, count 5, weapons carried concealed with an habitual offender, 4th offense notice, set for a preliminary examination today, excuse me, a probable cause appearances.
Edwin Milwaukee, P 54828, appearing on behalf of the people.
Neighborhood Defender Service by Jackie Pilkowitz, PA 1653 on behalf of Marvin Geary. I'd ask that the court waive his presence for purposes of this proceeding. I just spoke with him yesterday.
Okay, I will waive this. Here, Attorney Pilkowitz, do you have discovery?
Judge, I only have paper. I'm still in need of body cam and dash camera footage, which I believe the paper discovery indicates exists in this case.
People?
We will look into the digital and find out what's going on with that.
Otherwise, Judge, we'll just need an exam date.
Okay, does May 8th work for you? I'm trying to get all of our available dates together.
Judge, did you say May 8th?
Yes,
That is not a good date. I could do any other day that week.
how about May 9th?
May 9th works just fine.
I have, excuse me, 9, 9:30, 10, 10:30, 11.
I'll take your 10:30, Judge.
Okay. So it's set for May 9th at 10:30. The exam. With the hopes that you have your discovery in enough time to be ready. And I know that Attorney Pilkowitz, if you do not have discovery in the amount of time that you need it for the exam, copy me on the email with the prosecutor so that we can resolve it before the exam.
Understood, Your Honor. Thank you.
You're welcome. Have a good rest of your week.
You too.
Thank you. Attorney Marshall,
Yes, Your Honor.
good morning.
Good morning.
I am going to handle dismissal and inquire your case. Your client is in the hospital. So if you're okay with waiving his presence, then I am as well.
Okay, I can do that. Can we set it up for another PCC then?
Sure.
Okay,
Let me take care of this 8:30 exam, and then I will call you back. Mr. Love? This is case number 2356279, the people of the state of Michigan versus LeBryant Love, charged with count 1, assault with dangerous weapons, 1 is assault. Count 2, which is a misdemeanor malicious destruction of personal property, $200 or more, but less than $1,000 set for an exam appearances.
Your Honor, Edmund Milwaukee, C54838, on behalf of the people.
Good morning, Your Honor. Steve Mencken, D21562, appearing on behalf of Mr. Love.
Mr. Love, please state your full name for the record, please.
Yeah, my name is Brian Love.
Good morning, everybody.
Good morning, Your Honor.
Everyone ready?
People are not, we are missing essential witnesses.
Anything from defense?
Move to dismiss.
Make sure she got it. I knew what the request was. Okay, I will dismiss without prejudice as the people are not ready to proceed based off the witness not being present. It's been signed, so it should only take a couple moments.
And that's only to the felony.
Correct. Oh, so, thank you. The misdemeanor has to be sent over to Judge Bryant.
Okay, so are they gonna send me the data?
I can see the day right now.
Okay.
We'll rock it right now, Mr. Love. You're all set, Mr. Love. Your attorney will give you your date for the misdemeanor count.
We gotta get a new date.
But I think I might most likely consider that because I think he has no prior history.
Yes,
Counsel.
Oh.
Yeah.
This is Mr. Aliyah, Brendan.
May 22 at 8:35.
Okay, Attorney Lincoln, we have a date for a pretrial too.
Oh, okay, good.
You want me to write on the poster for you?
Okay.
What is it? 23rd.
You like her?
Yeah.
Okay, thank you.
Okay, ready on Stewart?
ready, Ryan.
Ready, Judge.
Okay. Make sure we have both. Okay, this is people in the state of Michigan versus Dante Darren Stewart, case 2355990. This case is charged with count 1, police officer fleeing third-degree vehicle code, count 2, stolen property, receiving and stealing motor vehicle. Mr. Stewart is also charged on case 2355998 with 1 count of weapons carrying concealed, count 2, police officer assaulting, resisting, and obstructing, count 2, weapons felony firearm, also set for a probable cause contest appearances.
Good morning, Your Honor, to your staff. Rana Hadid on behalf of the people, P62243.
Hey, good morning, Your Honor. Hugh Marshall, P48269, on behalf of Dante Stewart. Just one housekeeping matter, Your Honor. The CCW case that you mentioned, I have that set for PCC in front of Judge Giles tomorrow. Is that all been transferred to you, both cases?
That is correct. It's all with my court now, my courtroom. So if you are ready, I'm looking ahead at both PCCs. Okay, you're okay with that?
Okay, we can do that. You'd indicated that my client was in the hospital. Obviously, I haven't had a chance to speak with him, so I'd waive his appearance today and ask for another PCC.
Just so you know, Attorney Marshall, we received that information just now from Wayne County Jail. They just called us.
I'm sorry.
Did you hear what I said?
Did you say that he was here now?
No, I was letting you know how we received that information. We just received the call right before we called the case, and he's in the hospital.
I got you.
Okay, Attorney Haddad, do you have an objection to an adjourned PCC?
No, Your Honor.
Okay. The question is, how long will he be in the hospital? Did they say?
No, Judge. I can call back the number.
We're gonna check and see,
Dante.
if we can figure out when he'll be available.
Okay.
Is it? The jail does not have an answer as to how long. I would guess when we come back in a week to see if I receive any information from the county jail, I would email you both in the meantime.
Thank you. So May 8th,
May 8th at 8:30, does that work for both parties?
yes.
Sure.
Okay. All right, I'll see you all then.
Thank you, Judge.
Thank you, Your Honor.
Oh. Marvin here. Judge should raise.
So the gentleman in the Wayne County Jail, what is your name, sir? Either of the gentlemen in the Wayne County Jail, can you state your name, please?
Bryce,
Your full name, sir?
Bryce Smith,
You're an attorney present for Mr. Bryce Smith. Oh, wait, that's up right now.
No.
Can you call and see, who from neighborhood services? Neighborhood Defenders Handling Bryce Smith? And to the gentleman who stated his name but is on mute in the Wayne County Jail. Can you have a deputy unmute your device, please, sir? I have you, Mr. Smith, checked in. To the other gentleman in the Wayne County Jail, can you please have the deputy unmute your device so that I can hear your name? I can't hear you. Okay. Mr. Terrence Hill?
I'm sorry, Judge.
Yeah, I need to know his name.
His name is Christopher Harris.
Okay, thank you.
What is all this? She just asked.
Anyone ready for the case to be called? Are there any attorneys who are ready for their case to be called?
Good morning, Your Honor. It's the attorney Jennifer Colthurst. I'm here regarding Bryant Minor. You were kind enough to allow him to be tethered to a treatment facility last week. He was sent to sobriety house. However, he left the sobriety house and he is now at the jail, Wayne County Jail.
Okay, give me 1 moment. So you're gonna be there?
No, Your Honor, we're resuming at 10 o'clock for the murder trial. I'm sorry.
I sent an email already saying if,
So she responded saying that she was objecting. And that's why I came here I came here first. It's been literally all day, every day since last Monday. And we ended at 4 o'clock on Friday. And I haven't slept in a week and a half because of the stress. I don't need to show any disrespect to the court. It's just one of those things. It's like
okay, Attorney Colthurst, I am going to call the case now. All I have before me is an incident report for your client. I don't have a case number. It's the people of the state of Michigan versus Bryant Minor. I don't have a case number set for a tether violation today. Appearances.
Morning, Your Honor. Daniela Parrish on behalf of the people, PA 5495.
Good morning, Your Honor. Jennifer Colthurst, appearing on my P number is 52876. I appear on behalf of Mr. Bryant minor. The case number is 235622901.
Thank you. And as you stated off the record, Attorney Coulthurst, your client, I allowed him to be released on the tether so that he could get treatment at the Mariners Inn. He did not appear. Is that correct?
Your Honor, he did not appear at the Mariners Inn. However, he was taken or accepted into the sobriety house. So he appeared there, was there for a few days, but left. He's now at the Wayne County Jail.
Okay, next time, or can you let the court know that if he was, or if your client moved to another facility, because we gave the tether unit only the Mariners Inn.
And that was my understanding. I was shocked to learn that he was at another facility. I did not know that would have been possible in light of the order.
Okay. I know your request is to refer him for competency, but I need him to appear, because otherwise referring him to competency, he won't even know to show up to be interviewed.
Your Honor, can you have deputies bring him before, Your Honor? He's at the Wayne County Jail.
Okay, so we're not ready to call his case then.
Okay. I did not know whether it was a matter of just asking the deputy to bring it forth. Thank you. I'll wait.
Okay. Mr. Terrence Hill.
Good morning, Your Honor. Terrence Hill.
And Mr. Hill, good morning. I don't have you on the docket today. What are you here for?
No, I am here on behalf of my son, Harvey Arnold, which I believe you're hearing his case today.
I can't hear you. Say that one more time.
I am here in behalf of my son, Harvey Arnold, which I believe you're hearing his case this morning.
Yes, okay. You have to log on to YouTube, sir. This is for people who are participating in the hearings.
On the YouTube.
Your Honor, Mr. Hill may have some important information because Mr. Arnold is in the forensic center. So he may have had contact with him. I haven't. I don't have a way to contact him in the forensic center.
Your Honor, should they have a breakout room? Because I don't believe he should.
I don't know. Information on his whereabouts or what?
Well, I don't know what the court, we were having a review of his competency at this point, and I don't have a new report or anything from the forensic center as to his progress or hope for restoration to competency. His case has been lingering for a very long time.
And Mr. Hill, anything he provides, I can't take as, I need to hear from the forensic center.
Your Honor, that's why I was listening. If defense counsel is needing information and she believes he can provide information, maybe give them a breakout room before he goes on to YouTube.
I like to.
Well, I can talk to him on the phone. I have his number. I just didn't know if the court wanted to hear from him.
Thank you.
He's reading at G3.
O'Mara, the clerk called the forensic center. Do you want to wait a moment for them to call back, or do you want this adjourned for another 30 days?
I just don't, I don't know what the court wants to do with it. It was a review. If the court wants to hear from the forensic center, then, I could wait until they call back. Or we could.
there's no report provided as of yet, correct?
Correct. As far as I know, I haven't received one.
Right, I would like a report.
Yeah, I would think that would be best.
Yeah, let's see, where did this, did I inherit this case? From somebody? Oh, it's been over a year.
Is council aware if he's actually met with the, staff? And we're just waiting on a report, but has the defendant actually met with the, forensics?
He's
center?
actually housed at the forensic center.
But I mean, has MDHSS, or excuse me, HHS done an evaluation already? Met with
There's
them?
been a few evaluations already. I don't know if there's been a most recent one since he's been in.
For a brief adjournment of a couple of weeks and maybe I'm more defense in myself, we could all try to reach out to them.
I would like to wait for the forensic center to call back. Attorney O'Meara, if you don't mind, waiting a moment, they usually call back in 10, 15 minutes to at least let us know what the problem is or what the holdup is.
No problem, Your Honor. If I don't respond, if somebody could put it in the chat, because I'm on other Zooms too. So I'll keep trying to look back, but sometimes I can't have the sound on both to hear my name.
That's fine.
Thank you.
And also, if you're okay, I can give you an adjourned date also in the chat, if you don't want to go on the record.
Either way, I mean, I don't mind going on the record. I just don't, just want to let you know I'm got a divided attention at this moment.
Okay. All right, I'll message you as soon as we get something.
Thank you.
Thank you.
Good morning. Do you have Crystal Renee Tony Williams case up in here today?
So, good morning.
Okay, thanks.
Mr. Gary?
Yes, ma'am.
Good morning, sir.
Good morning, ma'am.
Your attorney already set your exam date. We already called your case at 8:30. I'm going to give you your information and you can log off.
Oh, yes, ma'am. I just wanted to log in just to make sure I showed my face, ma'am.
Well, thank you. Your preliminary examination has been set for May 9th at 10:30 in person at 36th District Court, okay?
Yes, ma'am.
So you're all set today. You have a good day.
Have a good day.
Attorney's for in custody.
Mark Turner's here.
Attorney Jackie?
Still waiting on the attorney.
Yes, Your Honor.
Okay, I have AKA Willis on. Bill, let me get the file and I'll call the case.
Okay.
Okay, this is case 2355796 for people in the state of Michigan versus Lisa Marshall, charged with count 1, forgery of document affecting real property. And Ms. Lisa Marshall is defendant number 1, also charged with count 2, uttering and publishing a document affecting real property. Count 3, false pretenses, $1,000 or more, but less than $20,000. With the habitual offender third offense notice set for an exam today at 11:30 a.m. Appearances.
Good morning, Your Honor. Latoya Willis appearing on behalf of the people, P64900.
And good morning, Your Honor. Attorney Brent Jaffe on behalf of Lisa Marshall, P81300.
818. And Your Honor, quick disclaimer, I'm not here to take advantage of or show any disrespect to anyone's schedule or time and efforts. And that's what I can tell you. And I apologize. That being said, I didn't anticipate this to go as long as it has. And I'm actually, as I was in the court this morning, I'm across the street now. We're resuming at 10 with the trial. And I'm just, unfortunately, I'm not able to proceed forward with the exam this morning. And I just respectfully ask for an adjournment. That's my position.
Hey, Willis, I received your email. If you'd like to put that on the record, I'd appreciate it.
Thank you, Judge. Yeah, so I received this request sometime this morning, I guess about 8:30 or so. And I was able to contact my witnesses and call them off. However, I just want to place my objection on the record because surely Mr. Jaffe had to have known he was going to be in trial, at least on Friday, and it would have been courteous to have informed me of that so that I could call my witnesses off. My witnesses took off work for today to be in court today, so it's a wasted day off. I don't know if they're being paid for the day, but I was at least able to call them and, keep them from wasting additional time and money on parking. So I just object to the fact that the notice was so untimely.
And Attorney Jaffe,
As I stated, Your Honor, and again, I appreciate Miss Wills' efforts, and I meant no disrespect. And again, we went to the last minute on Friday, and I just was not in the right headspace to reach out. And again, I accept responsibility. And again, I apologize.
okay, no need for me to admonish you. It was definitely inconsiderate for the people and the witnesses. APA Willis, you said you called off the witnesses. I was going to suggest this afternoon for an exam. Are you preferring another date, or would you like to try this afternoon if Attorney Jaffe is done with his closing argument?
See, Your Honor, I'm sorry. We're going to be starting closing this afternoon, Your Honor. At 10 o'clock, the prosecution is finishing with their proofs, and they're going to rest, and then we're going to do closing this afternoon.
Okay. So APA Willis, I guess next question is no longer, let's move now. So what day, I will make, based off of your complaining witnesses and anyone who you had to call up today, do you know what other dates this week they have available?
Judge, not this week, but does the court have May 1st or May 3rd available?
I will make it work.
And a time like 10 or 11, not the first in the morning, works for them best.
And Your Honor, I do apologize. I'm starting an armed robbery jury trial in Frank Murphy on May 1st. If the court could perhaps give us May 8th, that'd be most appreciated.
I can do May 8th.
May 8th, I have 9, 10, 10:30, 11, or 11:30.
11 o'clock works, Judge.
Okay.
All right,
I appreciate that, Your Honor. And again, Ms. Wells, please accept my apology. I didn't mean to show any disrespect. So that's what I can say.
Judge, did you say 11 or 11:30?
Whichever one works for you.
Okay, I've got 11:30 now.
Okay, so let's do May 8th and 11:30.
Thank you very much.
Okay, you all have a good rest.
Okay.
Okay, ready on Bryce Smith. Calling case 2356427, State of Michigan versus Bryce Smith. Mr. Smith is charged with count 1, robbery unarmed, and a misdemeanor, count 2, assault or assault and battery, set for a probable cause, however, the appearances.
Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing in person with Mr. Bryce Smith, who is appearing by Zoom from the Wayne County Jail.
Mr. Smith, can you state your name, please?
Bryce Smith.
Thank you. Good morning.
Good morning.
Okay, Attorney Cohen, do you have discovery?
I believe that paper and digital in this case.
Okay.
Yes, I believe I checked this last night and I do have both.
Okay. His exam date, I know he's in custody. He's in custody on this case?
He is, Your Honor, and frankly, he should not be. I think the court issued a personal bond with a GPS tether, and he has now been sitting for way longer, I think, than is standard for the placement of a tether. The information that I received is that he was initially told that he didn't qualify for a tether because they were unable to verify an address for him. I did provide a backup address, but I've heard no response from Wayne County Jail in terms of whether they can verify that address. And I have not received any kind of a message either through the court or from the jail indicating that he's completely disqualified from a tether. But I would ask the court to consider removing the tether requirement in this case. Mr. Smith at 19 years old, I don't believe has any significant prior record. He's single, has no children. I think he would be staying with his cousin, Sharon McGee, at 19180 Runyo, RUNYOH in Detroit. This incident took place in the hallway of an apartment complex where his father stays. And certainly he could stay away from that apartment complex during the pendency of this case. Also, again, I think it's appropriate the court can take into account the likelihood of conviction in this case. Although Mr. Bryce Smith is charged with unarmed robbery, this, by all accounts, arose from a dispute over the complainants taking photographs of Mr. Smith in the hallway. He snatched the phone away from them allegedly to delete the pictures, and that was, police responded rapidly. Mr. Smith was still on scene with the phone and returned it to police. So I'm not even sure that, from a factual standpoint, once the evidence is heard at the exam, whether this will even be any kind of unarmed robbery if there's no intent to permanently deprive. So we would ask the court to remove the tether in this case so that Mr. Smith can be out while the case is pending.
Your Honor, people would object. I'm not sure if Mr. Cohen indicated the date of when this was actually set. Because the defendant is in custody, I believe the court can set preliminary exam fairly quickly. the people would prefer to request a DSU report prior to just removing the requirement of the tether. I understand that there may be some defenses in this. However, they are serious charges. He knows where the people, I assume, reside in this building where his father resides, for the safety of the community and the severity of the charges.
I have to tell you on the phone. You have, I have to tell you.
Oh, thank you.
Good morning, this is Josie Sabree. How you doing? I'm on the record right now with prosecutor's office and Rice Smith attorney. And they're discussing bonds, but the issue is that he's not been issued a tether thing over 2 weeks. Do you have any information that these providers will get to make this one? His name is Rice, B-R-Y-C-E Smith. Mr. Jones was saying 419, the report's not ready, so just adjourn. So they can get the report. She said we can take 7 to 10 minutes. Other case,
Yes, Mr. Kirsch.
hi, this is just Sabree. Good morning. Pretty good. You have any answer questions on tether removal? Okay, we're on the record right now. Mr. Bryce Smith, our license. Can you provide information as to why what's going on with this tether or why you were issued a tether? So there is. Cardo is over here, right? So you can message her. Yes, I'm here.
So he is, I still know the list, but he got. We need to 25 people over here. So we get, should be out on Sunday with it tomorrow.
You see it happen, take longer than a week?
Hello, man.
Yes.
Yeah, it has been a week. He got placed on our list on Friday.
The 21st?
So, yeah, we don't do, enrollment for the weekend.
Okay.
So he is on the list. He won't be on there. To do that.
Okay.
Yeah.
All right.
He got placed for the, Friday, so he'll be out.
Okay.
Everything is clear.
I appreciate the quick response. Thank you.
No problem.
Have a good one. Okay, just receive information. He should have his tether by tomorrow or.
Okay, thank you, Your Honor.
You're welcome. So with that, are you ready to set the exam date?
Yes, Your Honor.
Okay. He will be out of custody. The week of May 8th. Pretty wide open.
Oh, Wednesday, the 10th or Tuesday, the 9th?
On the 10th, I have 9:30, 10, 10:30, or 1:30.
We do 10:30 on the 10th?
That's fine. May 10th at 10:30 for exam. In person and on that. Anything else?
I don't believe so. Thank you.
We're off the record on Mr. Bryce. Give us one moment. Give me one moment. I'm trying to figure out if I see it. Arnold, if you shut the phone. Today is the May 25th. May 25th. Okay, Mr. Jewell, in the Wayne County Jail, can you unmute your device, sir?
What did you say, ma'am?
I just wanted to let you know, you were just evaluated, recently with the forensic center, correct?
Yeah.
Okay, so, your report is not complete, so today, nothing is going to happen. I am going to contact your attorney, and let him know that you are to come back on May 10th at 9 o'clock, okay?
May 10th, yeah, I figured that I was having court on the 12th, I wasn't supposed to.
Hold on,
have
I
court
can't
today,
hear you. I can't hear you.
They didn't tell me I was, they told me I was having court today, but I'll tell them I'll tell them that there was a mess up again.
So yeah, we don't have, I don't have a report, so we can't move forward. So today, basically, nothing, it's just, I'm just telling you, since you're in front of me, your date, and May 10th at 9 o'clock, and your attorney will know as well, okay?
All right, where's the May?
You have a good day.
Thank you.
So the gentleman in Wayne County Jail, 8th floor. Who is your name, sir?
Yes,
What's your name?
Bryant Minor.
Okay, Mr. Minor, give me one moment.
What did you say?
Give me one moment, okay?
Okay.
Mr. Arnold? Did you find out what's going on with yours? Some comments. That's it? That's it? Okay.
The gentleman behind the bars, what's your name, sir?
Bryce Smith.
Okay, Mr. Bryce Smith, I don't know if you could you hear everything your attorney was stating about your tether? What we were discussing about your tether?
Ryan Minor?
Mr. Bryce Smith.
I heard what he said as far as the tether should be released, but I didn't hear no further information after that.
Okay,
Yeah.
so I called the tether unit. I allowed you to be out on tether. I checked the status. You should receive your tether tomorrow or Wednesday. Okay?
Tomorrow or Wednesday?
Yes.
Okay.
And also you have an exam date set for May 10th at 10:30 a.m. Your attorney will discuss with you all the details of that before you get here. That'll be in person. Since you'll be on tether, you have to appear in person, 36th District Court on May 10th at 10:30, okay?
Okay, thank you.
You're welcome. So you're all set.
Okay.
And Mr. Harris, your attorney is not present. That's why we're waiting for to call your case. And Barrett, just one more in custody, and then we can handle your matters. Okay, Attorney Coulter's ready on Mr. Bryant Minor. So we're back on the record as people of the state of Michigan versus Bryant Minor appearances.
Good morning, Danielle. I'm here on behalf of the people, P85495, and would you repeat the defendant's name?
Tether violator.
Thank you.
Good morning, Your Honor. Jennifer Colthurst, P52876. I appear on behalf of Mr. Bryant Minor, case number 235622901. Mr. Minor, please identify yourself.
He's on mute. Mr. Bryant, you're on mute.
Okay, can you hear me now?
I can. State your name, please.
Okay. Yeah, I'm Bryant Minor 2559.
Thank you. Okay, Attorney Coulter, what is your request today?
Your Honor, I did have an opportunity to speak with Mr. Minor as well as his mother. And my client does have a history of a mental health history. He's been diagnosed with schizophrenia and bipolar disorder. I am concerned about his ability to assist me in his defense and whether the mental illness has impacted his ability to appreciate the wrongfulness of his actions. And consequently, Your Honor, I'm respectfully requesting evaluation for competency and criminal responsibility.
Okay. You said just for criminal responsibilities?
And competency.
And competency.
Trying to repeat the.
Number. 2305-622-901.
Thank you.
Okay, I will, anything for the people, I guess I should.
No, I have no objection, Your Honor, to having a competency evaluation for responsibility conducted.
Okay, so I will have him referred, I don't know the timeline, Attorney Coulter's, but I will put in a referral today to have him evaluated.
Thank you.
Anything else?
I know at one point, at least last week, my client wanted to be released from jail in order to enter a treatment facility. However, it seems as though he's been having some difficulty remaining at a facility.
So how about we readdress this after he's been evaluated?
Okay, do you understand that, Mr. Minor?
I didn't hear the reply. I mean, I didn't hear. What did she say?
I said I will revisit you going into a treatment center after you get evaluated by the forensic center.
All right, because look, I wanted to max out my time.
So I can have a better understanding of what your needs are, because I allowed you to go get treatment and you left the center. So I'm going to have the forensic center evaluate you in the county jail and let me know what you need best.
Thank you, Your Honor.
You're welcome. Anything else?
Will we be getting a date certain, a return date for competency?
Let's do 30 days to see what we can get from the forensic center by then. So May 25th. 9 o'clock.
Already. If I may have permission to, is it going to be via Zoom, Your Honor?
Yes, it'll be Zoom.
Alrighty. I have an 8:30 sentencing at the Macomb Circuit Court. I probably will be able to zoom in a little after 9 if everything goes smoothly with my 8:30 circuit. Okay, thank you. Have a good day, everyone.
You as well, thank you.
Thank you. Bye-bye.
Bye. Mr. Hill? Mr. Terrence Hill.
Yes, Your Honor.
So we don't have a report, so his next date will be on May 25th. Gonna come back in, he's still being treated.
May 25th. Okay, thank you, Your Honor.
You're welcome, have a good day.
You too.
Attorney Richards, good morning.
Good morning, Judge. I'm here on Harvey Arnold, which was a competency review without a report.
Oh, I just gave, you still don't have any information, he's still being treated, so I just adjourned it for 30 days.
Okay, thank you.
May 25th, 9 o'clock.
Great, thank you.
You're welcome. Mr. English,
Yes, I'm here.
you're an hour and 15 minutes late.
I just got the Zoom information. I asked my lawyer for the info. I just not received it. I apologize.
You can get it off our website, so you don't have any excuses next time, okay?
All righty.
Your attorney is not present. I have you checked in. We'll wait for him. You have other matters to take care of, so put your device on mute until he arrives.
All right.
Attorney Mitchell?
Good morning, Your Honor. I have a live preliminary examination scheduled today at 1:30. I've just asked the Attorney General to see if she can Zoom in because I wanted to ask for a new date. She put my discovery on a junk drive. I've been trying to open the junk drive and I thought it was maybe my laptop, so I used my significant other's laptop, right? I used the kids' lap. Everything was saying that it was a BitLocker code that I need to find, but I've never experienced that. So I was trying to figure it out. I went to a public library today to see if I can open it, and the tech person told me that it's an actual lock on the junk drive. So I sent her an email to see if she could send me a code to unlock it, and she said she had an assistant or someone put the information on there. And it's like 200 pages of information, Your Honor. So I haven't been able to go over the discovery yet. So I wanted to get a new date.
Okay, well, I need the AG here to do that.
Does anyone have her number? Because I don't have a number for her. I just have her email.
Oh, I have the Wayne County Prosecutor's Office on here as the people's information. You can find it on the State Bar.
Okay, I can try to find her. I just sent her an email to Zoom in, so I will just Zoom in when we can. I just wanted to kind of give you a notice and heads up before 1:30.
Okay.
But I think, I believe her mother is being tried as well, so I believe they'll still be coming at 1:30. But I tried to call that attorney too to see if they had the discovery and that if I can get it from them, but their phone is going straight to voicemail. So
You can call NDS and they can contact Attorney Washington. Do you have their phone number?
I can look it up, Judge. I'll look it up. Yeah, so when she zooms in, or we'll just zoom back in and ask for a new date. Because I don't feel it's just too much discovery for me to go over that fast too.
Okay, well, I'll let both parties be heard on the record.
Okay, thank you.
Attorney Barrett, I'm calling your matter in 2 minutes.
Hello.
Hello?
I'll tell you, I'm sitting at the top.
I asked her to bring it. She didn't respond.
Hold on, I'll be silent.
Attorney Kraus, good morning.
Good morning, Judge.
We have a motion hearing that was scheduled for 8:30. We're about to start. Is your matter just to set a date, or what are you trying to do?
Judge, I'm planning to send for competency, criminal responsibility, and competency to waive Miranda.
Okay. Still have more. And we're on the record, this is 2159420, the people of the state of Michigan versus Christopher Ruben Harris, also known as Christopher Moore. Count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, weapons, firearms, possession by a felon. Count 3, weapons carrying concealed. Count 4, weapons, loading firearm. Count 5, weapons, loading firearm. Set for a probable cause conference.
Good morning, Your Honor. Daniela Sherridge on behalf of the people standing in for Laura Nersessian today.
And good morning, Your Honor. Sarah Kraus, P81830, appearing on behalf of Christopher Moore, who is present via Zoom through the Wayne County Jail.
And is it correct, Attorney Kraus? Oh, let me get your client here. Mr. Harris, can you unmute and say your name, please?
Can you tell me what's going on, please?
Not until you say your name.
Christopher Harris.
Thank you. Today is being set for a probable cause conference to discuss any preliminary matters before a preliminary examination, if it is one to be scheduled. Your Attorney Kraus has just mentioned off the record that she would like to refer you for competency. Attorney Kraus, is that correct?
That is correct, Your Honor. I would like to refer Mr. Harris for competency, criminal responsibility, and competency to waive Miranda.
Okay, anything from the people?
Your Honor, people have no objections to that issue.
Okay, I will have him referred for all three. I have no idea what the timeline is right now with the forensic center. I would like to set a date 30 days out, and then of course, if there's no report, then come back again, but I don't want to set it out 60 days. If they do evaluate him, so they're 60 days custody.
Thank you, Judge.
You need to speak to Mr. Harris in a breakout room.
I will, yes.
Mr. Harris, your attorney is going to explain to you what you may not have understood in more detail and in private, okay? All right. Have a good one, Attorney Kraus.
So, 25th, like the other ones?
Might as well do it 25th, yes. I forgot to give her the date. May 25th at 9 o'clock. Please email council letters on 525. Okay, people of the state of Michigan versus Jaleel Dotson, case 2356298. Mr. Dotson, count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Set for a motion hearing at 8:30 today. Harris.
Good morning, Your Honor. Daniela Sherridge on behalf of the people, P85495.
Good morning, Judge Hannah Barron, P85265, representing Mr. Dodson, and I'll waive his appearance for the purpose of today.
Okay. And Attorney Barron, this is your motion, so you may begin.
Yes, Judge, I did receive in this case police reports, digital discovery, and I requested unredacted police reports because the reports that I received were heavily redacted, multiple witnesses, contact information, date of birth, addresses were redacted out. I'm asking for that information. It's information that I'm entitled to under the discovery rules. MCR 6.201 makes it mandatory that the people do turn over police reports. And as I cited in my motion to the court, our Court of Appeals in People v. Jack explicitly held that unredacted discovery is what is covered by MCR 6.201 and what the people are required to turn over.
Anything for the people?
Yes, Your Honor. Thank you to defense. I was able to review defense's motion that was submitted, I believe, Thursday or Friday, and did speak to our office. It is the people's position to, we will provide that so long as defense signs a protective order prior to us releasing the unredacted discovery. I can have that typed up for you this afternoon. And if you can get that back to us, if you want to do a follow-up on Wednesday, but if you want to get that back to me today, I can have the discovery unredacted sent to you tomorrow. But I just have to type up the order, order protected ordering the unredacted discovery.
That's fine. And the protective order is that it can't be disclosed to anyone beyond the defense team.
Beyond the defense team, and no third parties, and actually the defendant is deemed a third party in the discovery order, you'll notice that, but yourself and any other defense counsel that is working on your team is included. However, since it is part of a larger group, if let's say you are taken off of it and a new defense attorney is brought in, even if it's from your unit, that was not originally part of it today, they would have to re-sign the discovery order.
Understood. That's fine. Thank you.
Okay. Attorney Barron, sorry for the delay. You were here on time. Thank you for your patience. So once I receive the protective order from Carriage, I will sign it and hopefully we can move forward on this case.
Okay, no problem. Thank you, Judge.
You're welcome. You have a good rest of your week.
You too.
Okay. Okay, ready on Cedric Jones?
We are, Your Honor.
Versus Cedric Jones, case 2355741. Mr. Jones is charged with one kind of weapons carrying concealed set for a probable cause time for submitting appearances.
Good morning, Madam Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Alexandra Cho with the Neighborhood Defender Service of Detroit, P85948, appearing on behalf of Mr. Jones. Just to confirm, Your Honor, this is Cedric Jones. I thought I'd heard a different first name.
Cedric Jones is what I think I said it, but it's Cedric Jones.
Okay, I just wanted to make sure. And Mr. Jones is present via Zoom.
I see. State your name, Mr. Jones, your full name.
Cedric Darrell Jones.
Good morning.
Good morning.
And you have discovery, Attorney Choate?
Yes, I believe we have received all digital. I will ask prosecutor, there are 2 current body cam footage videos. I believe there were 4 officers. So if there are additional digital discovery, I would request that be uploaded. But my conversation with Mr. Cal Major is that it was just those 2 videos that have been uploaded.
Counsel, if you would like to email me directly and specify which officers you are seeking, I can forward your email. So I always ask the defense is very specific. So I'll forward it to the OIC and try to get an explanation for you if there is any. Often if the other officers are detectives, sometimes I've been informed that they do not wear body worn camera, but I do not know which officers, so feel free to directly email me today and then we'll start the process of trying.
Perfect. Thank you so much.
Okay, Attorney
And we would just be requesting. Oh, go ahead, Your Honor.
No, you're on the right path. That's what
I
I'm
was
getting ready.
exactly. We would just be requesting a preliminary exam date, Your Honor.
Okay, I sent you some dates and also I sent you Ms. Carriage's email address, just in case you didn't have it.
Perfect. For the date, Your Honor, it looks like actually May 11th at any of those times would work perfectly.
May 11th. Let's do 9 o'clock, start off the morning.
Perfect. Thank you so much.
Mr. Jones, your exam has been set for in-person, May 11th at 9 o'clock at 36th District Court. You are to be in person. You understand that?
Yes, ma'am.
Okay, anything else from either party?
Perfect. Thank you so much, Your Honor.
Welcome, you all have a good day.
You too.
All right.
Attorney Chambers, morning.
Good morning, Judge.
I saw your message for Mr. Jewell. He was seen on the 19th. So the report won't be complete for another 7 to 10 days. So I set a date for May 10th at 9 o'clock. Can you make that day?
Yeah, I'll make it happen. Thanks, Judge.
And I let your client know, he appeared on Zoom. I let him know this date as well, and the deputy.
Oh, okay, I appreciate it.
Welcome. Have a good one.
You too.
Attorney Krimpay?
Good morning, Your Honor.
Good morning. Ready on Gardner?
Yes, I am.
Okay, we're on the record. This is the people of the state of Michigan versus Tamika Gardner, 230562140. Ms. Gardner is charged with 1 count of weapons carrying concealed set for a probable cause conference today. Appearances?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Jabari Pay P81745 on behalf of Ms. Tamika Gardner, who is not present via Zoom, but I'm respectfully requesting a waiver of her presence.
Have you had any contact with Ms. Gardner?
Absolutely, Your Honor. I contact her every day, including this morning. In fact, I'm not sure what happened with my calendar, except maybe that I clicked the date next to the date, but I thought this hearing was tomorrow. But in any event, I have also spoken with Cal Major regarding this matter, and he indicated to me, and I have it through email, that he was going to actually put this matter back on Judge Robbins' docket for reconsideration of her accepting the plea offer available. We happened to get additional discovery after we set this matter, or we said we were ready for a preliminary examination, which got this matter transferred to you. Again, after that, we got more discovery, and we're requesting that it go back to Mr. Nager, which he agreed to do. But I don't know what happened in the interim, and of course, the system, is down, so we can't really check on what's going on. But the offer that he gave was an attempted CCW. If that offer can be made in this court, we can leave it here. Otherwise, I'm respectfully requesting that it be returned as Mr. Nager said it would be.
Your Honor, our procedure at the Wakeline Prosecutor's Office is indeed, as was told to defense counsel, is that it needs to be sent back because all CCW pleas have to go through Cal Major and Judge Robinson's court. We don't have, you don't have objections to having it returned back to Robinson's courtroom.
So we'll set it for, Judge Robbins' courtroom. You ready for a plea date, or do you want to go to, or a different date? Or are you ready to just set it for a plea?
Well, my client hasn't necessarily decided that she's going to accept the plea. I just wanted that offer back on the table, while we negotiate, or at least I go through them with my client, but we just wanted the opportunity to do so.
I'm sorry, I don't mean to cut you off, but since you've indicated that she doesn't, the procedure is different. We will transfer you back to Robinson and allow you to take the original if indeed your client intends on taking it. We don't go back and forth for her to reconsider. So if she has not indicated to you that she is going to take that plea, I would insist that you set a preliminary exam date here, because we're not going to transfer it back unless there is a certainty that she's taking the plea.
Attorney Prince, I got something. How about you have your client come back tomorrow, put her on the record appearance and see what she wants to do, and then we can move forward from there, okay?
That sounds reasonable, Your Honor.
I already have a date. If she's ready to take the plea, it'll be May 2nd if she goes back to Judge Robbins.
Okay. Okay, I'll be back tomorrow morning, 8:30.
Okay, have a good one.
Thank you very much.
Yeah, I'm sure he does. I don't, today is not. I saw it. Okay. Mr. English, your attorney still has not appeared. I don't know what to tell you other than wait.
Do you want me to call him, or?
We have
He just texted me the Zoom information about 20, 30 minutes ago, and so, but I had asked him for that about an hour previously, so.
Mr. English, what I'm going to do, I'm not going to penalize you. You are doing your best. You can either wait or you can come back tomorrow at 8:30 sharp. Same Zoom information.
Is it a way I can call him and give it like 10 more minutes? Because I have things to do as well. I mean, I'm not trying to, I'm here and I'm waiting on my attorney to be present and he's not present, and I'm going to have to reschedule and be here tomorrow. So can I give it another effort and see if I can get this accomplished today?
Yeah, I said you can either wait for him to show up or tomorrow. Yep.
Okay, yeah, I'm gonna wait.
Okay, I'm gonna put you on mute. We got a lot of stuff to handle, okay?
All right.
Okay, now to the in-person.
That's a real judge pro sector.
Yeah. If he doesn't hear today. All right, let's do some catching. Thank you. Mr. Turner? Yes. Okay, good morning to you, sir. Are there any waivers or dismissals that can go on the record? Okay, let's handle Mr. Turner.
Your Honor, I'm gonna check with our 10 o'clock defense counsel to see if their waiver, if that would help.
Yeah.
Things along.
Thank you. This is the people of the state of Michigan versus Mark Bernard Turner, case 2356077. Mr. Turner is charged with 1 count of larceny from the person set for a preliminary examination. State appearances.
Edward Milwaukee, 25488, appearing on behalf of
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing in person with Mr. Mark Turner, who is present and out of custody, also in person. Mr. Turner, can you say good morning to the judge and say your name?
Good morning, Judge. My name is Mark Turner.
Good morning. Everyone ready to proceed?
Yes, we are, Your Honor. People, Kenneth Smith.
Okay, before Mr. Smith comes in, are there any preliminary matters?
Just the sequestration motion if there's more than one witness.
Okay. One witness?
One witness.
Okay, and there's no one in the courtroom, other than attorney, staff, and Mr. Turner. If there's anyone on YouTube who may be watching, or on Zoom who may be a witness, potential witness in this case, if it were to be moved forward, now's your time to log on. So with that, you're going to witness. Mr. Walker. You did call.
No, Your Honor, there was actually one preliminary matter I meant to bring to the court.
Do we have, witness step out?
I don't know that it's going to impact his testimony, but either way, it's just discovery related, Your Honor. I had sought reports from the prosecution and the Detroit Police Department in this matter related to several other, I guess, similar alleged robberies or thefts from marijuana driver deliveries in which Mr. Turner apparently was a suspect. But my position is, since he's charged with one, there's, I guess, a series or a rash of these that have apparently happened. And there's suspicion that he may have been involved with others. There may also be exculpatory information in those reports as it relates to other suspects. I believe the suspicion is that a single person committed these crimes, but then there's all these other reports out there, at least that have been referenced in the material that I've been provided. And if there's any indication in those other investigations that another individual has been identified or there's another suspect, that I believe would tend to be exculpatory. And I have requested this and not received anything from the prosecution on that. Also, I don't know if there were any video or audio or video recordings of the complainant's statements in this case. I have a written statement, but I had also requested any digital related to those. And again, haven't received any, might not exist. But.
Your Honor, the officer in charge is here. He's indicated to me that he's only the officer in charge on this case, and he doesn't have any digital or anything else regarding other cases regarding
Mr. Turner, regarding Mr. Turner?
Regarding Mr. Turner.
Attorney Cohen, your understanding is from the discovery that he may be involved in other cases?
Yes, that suspicion has been stated in the investigator's report. And yeah, from the material that I have, including the interview of Mr. Turner. Though, of course, I suppose in the interview, they could have been sort of telling him, well, we believe he did these other ones in order to try and get him to admit. But yeah, I believe it's referenced in the material that I did receive, that there were a number of these similar robberies that they had to have developed Mr. Turner as a suspect in some fashion to include him anyways.
Sir, can you say the name for the record?
Detective Linwood.
Linwood?
Yes.
Good morning. You're the OIC on this case only?
Yes.
Did you prepare that discovery or that incident report or investigator's report?
Yes.
Okay. And it's my understanding Attorney Cohen is saying that Mr. Turner is implicated or maybe implicated in other?
Yes.
Okay. And do you have any other information that Attorney Cohen is referring to as far as anything exculpatory that
We had some similar cases of the same circumstances, and I had another detective in my office who had the same circumstances. He had Mr. Turner as a suspect as well. I think I was happened in the same area. So I said, let me get on, line up this person up to the same line to my.
On another case?
I just took the name, I just took his name and this, and presented him the lineup to have the same MO in the same area.
Mr. Smith?
Yes.
Can you step out for a moment?
Thank you, Ben. But yeah.
Okay, so you're saying you showed a lot of the individual, Mr. Smith, right here?
Yes.
Oh, okay. I just wanted to make sure if it was only this case.
Just this case, it had nothing to do with those cases.
Attorney Cohen, does that clarify anything for you?
I mean, it confirms in my mind that there are at least multiple other investigations, or at least one other, in which Mr. Turner was developed as a suspect. But again, if there's any indication that he didn't commit some of these other similar circumstance offenses, it's my position that that would be potentially exculpatory, or again, if someone else was identified. And that's why I made the request for that material.
And you don't have any information on that, correct? Okay, so I signed a discovery order. And that's, well, it depends on what happens in this case, actually. But it's ongoing. So if there's any information, you want me to clarify that if this case is found over, I can do that. And if there's someone who is implicated as not your client, that information needs to be provided to you. Does that help?
It does. I mean, obviously not for today's purposes, for
Right.
purposes of the probable cause conference. Certainly, had I been provided with any of that material, I might have been, attempting to introduce that evidence to counteract any evidence of probable cause. But so I just wanted to bring that to the court's attention.
Okay. I am not going to adjourn based off of that. The officer in charge doesn't have any information, but it is found over. That discovery order can be amended to clarify that that information should be provided to you once it's known.
Thank you, Your Honor.
Okay, the fifth floor is Whenever you're ready.
Sir, could you state your name
Kenneth Smith.
and what brings you to court today?
I was robbed
Did that incident occur on March 20th of this year?
roundabout, yes.
And where did that occur at?
I believe it was on Calvert Street.
That's within the city of Detroit, County of Wayne?
Yes.
What were you doing in that area? Oh, let me back up. What is your job?
I'm a delivery driver for a House of Dane dispensary,
Okay, and exactly what you may dispense?
marijuana.
And what were you doing in that area?
I was dispatched to a call by a gentleman, a young man. I don't remember his name, but as part of our procedure, to call him when I'm getting close so he can be clear for my arrival. And I did that.
Is that the man in this courtroom today?
Yes.
Could you point him out and give a description of the piece of clothing he may be wearing?
I'm not object, Your Honor, at this time, the lack of foundation as it relates to an identification of what man we're referring to at this point that he's identifying.
You said the man who, I thought it was the man who delivered or ordered the delivery.
Yes, sir.
Right, but the only testimony so far has been about a call that's been made, so I would also object to facts not met.
The delivery person that Mr. Smith was referring to, the person he was delivering.
Let me ask you this. You made the phone call?
Yes.
Then what happened?
I told the guy that I would be there shortly. When I pulled up, he was waiting for me in front of the house like he said he would be.
And who was this man?
The gentleman sitting behind me.
Could you identify a piece of clothing that he's wearing?
Black shirt.
Let the record reflect that the witness has identified Mr. Turner as the man that he was meeting. Thank you. What happened next?
Well, like I said, I told him I was coming. When I got there, he was standing out in front of the house, the address that he gave to us, whatever. So I pulled up on the opposite side of the street. He's on the right side. Well, he's on the left side. I pulled to the right side of the street. He began to walk over towards me. I motioned for him to hold on and told him that I was getting out. There's a car procedure to walk to the door. So I was walking out, he stayed walking towards me. And he's got a lot of cash in his hand. He's trying to pay me first. I'm saying, hold on, sir. I haven't even checked your ID yet.
Okay. Why do you have to check his ID?
I have to make sure it's him. I have to make sure he's of age. I have to make sure it's who I'm delivering to.
What happened next?
He stayed trying to pay me. I said, I have to have your ID. And so he told me that his ID was in the house. He got locked out of the house when he went to the ATM to get money for me. And so I told him, well, I can't help you. I have to have your ID. So he pulled out his cell phone and as if he was talking to somebody, and I said something about when would you be coming back? I guess somebody was let him in the house or whatever.
Did you hear any response?
No, I didn't.
Okay.
I didn't hear anybody on the phone. I couldn't hear him. He was a good 2 feet away from me. I'm sitting down in my car. So like I said, he got his back to me. So I got all my stuff ready to get out to finish the transaction. He turned around and grabbed the bag off my lap and took off running.
Okay. Let me back up. So you're in your car.
Yes.
Okay, he's approached. He doesn't have his ID.
So
you're still in your car.
Correct.
You're communicating how?
I had my window down and like I said, I told him that I couldn't do anything for him without his ID. He got on the phone and I must say pretended to actually
narrative.
Yeah, just.
He got on the phone. Right, he got on the phone.
Okay.
And I heard him asking somebody when they will be.
Objection, Your Honor, there's no question.
Yeah.
narrative.
So, Mr. Smith, make sure that you're answering the question. So these objections, I'm not sure if you understand them or not, but we're asking questions for you to respond. You can't just tell the story without question.
Okay, so your window's down, he's off the phone now. What happened next?
He turned around and grabbed the bag and took off running.
Okay. And did you see which way he ran?
Yes.
Which way did he run?
He ran, I'm on Calvert, I'm not sure directional. I was on Calvert facing this way. He took off running at the very first corner, that's right there. So, yeah, we met on the corner. The house is the second house off the corner.
Okay.
So he took off running right at that corner.
And that's this gentleman here.
Yes.
Did you ever did you ever receive any money for?
No, I didn't see that, no.
Okay. And what did you do next?
I called my dispatcher.
Okay. I have nothing further.
Mr. Smith, this didn't come out earlier, but about what time did you arrive at this address on Calvert on March?
We're close about 9 o'clock, roundabout.
And March 20th at 9 o'clock, it would have been dark out at this point.
Yes.
Right, so no natural lighting in terms of the sun was not out anymore.
No.
And artificial lighting, there any street lamps or anything out there?
Yes.
Would you say it was well lit, poorly lit? How would you describe the lighting out there?
Well, we're talking about the church, so I'm gonna say, in between poorly and well lit.
So the artificial lights they're spaced out a decent ways, correct?
Correct.
Now, you got a call to come out, was it to 2078 Calvert?
That sounds about right. I don't remember the address, the numbers.
And the name of the person who placed this delivery order, that was an Andre Hayes. Does that sound familiar?
That sounds about right.
And the phone number, do you recall the phone number that you used?
No, I wouldn't know the phone. I would never see the phone.
If the written statement that you provided to Detroit Police Department regarding this phone number said it was 313-585-5946, does that sound like that could be correct?
Remember that's on our, that was on our invoice, our manifest.
And that number appearing on that manifest would indicate that's the number that the customer called from to place an order?
I can't say that because we called through an app, so I called him through an app. So I never, it's not like I punched in the number for him.
When you first arrived, you said this individual started walking across the street towards your vehicle?
Yes.
And you said you motioned to him. What exactly did you do to motion to him to wait?
I told him to hold on to come to him.
Did you actually tell him that?
Yes.
And at that point, when you motioned to him, you started to gather up the merchandise that this individual had placed an order for?
Well, yeah, I had several orders. I had to look through the orders to find his order.
And where were these orders in
They
your
were
vehicle?
on my passenger side, on my passenger.
So, and this individual who was crossing the street, walking towards your car, was coming towards your driver's side window?
Yes.
Right, and after you motioned and said, wait a minute, I gotta come to you, you turned to your right to figure out what was going on with your merchandise on the passenger seat?
Well, not exactly, not quite yet. He's then coming towards me, he's got a wad of money in his hand. And I'm telling him, I can't take your money first, I have to see the ID. So that's when he told me that he didn't have an ID.
But you were starting to look through the various orders you had on your passenger seat?
Not yet.
Okay. So at what point did you start to look?
Once I told him that he didn't have, that he wanted to need an ID, he called someone to get an ID, to get in the house, he said. Trying to find somebody to get out. That's when I began to look through the bags, whatever, do the stuff, and I'm thinking now I'm going to proceed with the order. Because he's going to get his ID. So I was driving, looking through the bag again. Once I got his bag, I set it on my lap. That's when he got off the phone, he grabbed the bag and took out running.
So when this individual walked up, you had fair to say, a brief conversation with him about needing his ID.
Yes.
So he came up with a wad of cash in hand. Did he say anything as far as here's the money or where's my order? Did he
No,
say?
he asked me was I was house of that.
And how did you respond?
Yes, I was house of that.
And then again, did he offer money to you? Did he?
Yes, he came over with well money. He was trying to pay me first.
And you explained to him that you needed an ID before you could sell anything to him.
Right.
And at that point, that's when he appeared to get on the phone and turn around.
Yes.
And his back was to you when he was on the phone, or at least appeared to be on the phone.
Correct.
And how long would you say he was on or appeared to be on this telephone call?
A couple seconds, few seconds.
And during that time, saying after he turned around, was on the phone, that's when you started to reach in.
No, I was like, as he turned around, he was like, yeah, I'm gathering things up that I need. I gotta have my clipboard and my bag and my phone to get his ID. Take pictures of it.
When you first arrived, you didn't have any reason to be suspicious that anything bad was gonna happen that night, right?
Not at all.
So, and you said when he's on the phone, you're having to gather up the order, right?
Right.
And you're having to get your phone,
Right.
because you're gonna need to take a picture of his identification.
Right.
So during that time period, you're not really paying attention to this potential customer, correct?
No, not at that time.
So all in all, in terms of the amount of time that you would have had to see this individual's face, fairly brief, correct?
Fairly good.
Now, this individual that approached was wearing what kind of clothes?
He had on a red hoodie and he had on a red jogging pants. Red with white stripes,
And was the hood of this sweatshirt pulled up or down?
Up.
Nothing covering his face?
No, it wasn't covering his face.
Only partially covering his hair?
Right.
And how would you describe the hair of the individual?
I really didn't, I couldn't see his hair. He had his hood on. So I just had to speculate with his hair. Like I couldn't see.
When you made a statement to Detective Woods with Detroit Police Department regarding this case, correct?
Yes.
That would have been March 21st.
Right.
So you described the individual who committed this theft as having short hair. Do you recall that?
Yes, I do.
And you said maybe he had a mustache?
A light mustache, yes.
And do you recall speaking to an investigator from Neighborhood Defender Service by the name of Angela Bassetti recently?
Maybe.
Okay. It's a female investigator who sat down with you and I think maybe your corporate counsel.
Okay. Yes.
You recall that conversation?
Yes.
And during that conversation, you also described the hair of the individual that took this marijuana as maybe having a fade. Do you remember that? All right. And can you describe what you meant by a fade?
Like I said, because I didn't see any, I couldn't see any braids or anything, so I was left to assume that it was fake. That's my.
So from what you could tell, it was short hair.
Right.
You didn't see any braids.
No.
You didn't see any dreads or dreadlocks.
No.
And again, what is a fade? Can you describe what kind of a haircut that is?
That would be like my hair, but about right here it starts to blend down. About this mountain, but it starts to blend down.
So more like very short on the
To
sides.
ball. Blends all the way down to its ball. That would be a ball fade.
And you could actually see maybe what would have been shaved skin on the side of this individual's head?
I could not, but I said I'm left to assume what the hair was like. That's what I was doing.
You were not looking at this individual when he reached inside the car and grabbed this thing off your lap. Is that fair to say? Your attention was elsewhere. So I mean, your attention was focused elsewhere when he reached in the car and took this bag off of your lap and then took off running. Now, the individual, this Alma customer who approached on March 20th, you had never seen that individual before?
No.
And as far as you're identified Mr. Turner as being that individual, I mean, other than you say that night, you've never seen Mr. Turner, who's present in court here before, correct?
No.
Not correct, or no, you've never seen him?
No, I've never seen him before.
As far as the individual that took this marijuana, did you notice any other distinguishing features or anything in the person's face that stuck out in your mind? No. Did you see any tattoos? No. And you were able to see this individual's hands that were bare?
I don't recall seeing his hands.
Now, this took place March 29, about 9 p.m., correct?
Correct.
And when this happened, you did not call police right away, correct? No. You actually went on and did some more deliveries that night, is that true?
Correct.
And then you did not go to report this to Detroit police until sometime in the afternoon, March 21st, is that true?
Correct.
And is it fair to say that your memory of what happened would have been fresher the night of the actual theft? Is that fair to say?
Very.
And at some point you were withdraw that question. I can just have a quick moment to- Thank you, Mr. Smith. I don't have any further questions.
No, Your Honor. Hallway or you leave, you can just leave the courthouse if you would like, or did you wait?
I'm just at.
You can leave if you want to wait in the hallway to hear the results. Any other witnesses from people?
No other witnesses, Your Honor.
Okay, once Mr. Smith steps in the hallway, you can begin your argument. Action.
Okay. Open. Your Honor, we ask that the defendant be found over on the count one of larceny from a person. We reserve pardon.
Attorney Cohen?
Thank you, Your Honor. We're asking the court not to find this over based on really the only evidence that's here, which is an identification. There is absolutely no evidence other than an identification of Mr. Turner by a complete stranger indicating that Mr. Turner committed this offense. There is no physical evidence, there is no confession, there is no covered stolen property. What we have here is an individual who late at night with no reason to be suspicious, no reason to be particularly alert or paying attention, had a very brief interaction, conversation with an individual who then turned his back on Mr. Smith and then supposedly reaches in and takes this bag of marijuana or this delivery and runs away. Under the circumstances, Mr. Smith is unfamiliar with, didn't know Mr. Turner. It's again late at night. He admitted he had a very brief interaction with Mr. Turner only. Under circumstances again that would not have heightened his awareness or suspicion. I would also note that Mr. Smith described the individual as having short hair, possibly a fade, maybe a mustache. Didn't note any dreads or braids or any tattoos. Mr. Turner here has dreadlocks in his hair and a tattoo on the left side of his neck. These are identifying features that even if partially covered, and I think that was the testimony Mr. Smith indicated that it was partially covering his hair, that an individual would have noted at the time. So I understand probable cause is a low standard, but this is a situation of a witness with very little actual opportunity to make an identification in this case. We'd ask the court not to find it. Thank you.
Your Honor, first of all, he has identified, Mr. Smith has identified the defendant in here before. And as far as identification, no dreadlocks or other facial features or hair features was partially covered. And those are all things, mustaches can be shaved, dreadlocks can be added on, or I shouldn't say added on, but be done later at a different date. I mean, since this crime has hey, I've had 2 haircuts. So it's easy enough that the defendant's hairstyle could easily be changed between that time and the time today. And we asked, as far as we have a positive ID, and that's enough to get for probable cause, and he has it for benefit out.
Okay. The court heard testimony from one witness, Mr. Smith. And I do believe the people have met burden of proof here. It will be a question of fact, Attorney Cohen, regarding the identification and the raised. Even at the probable cause stage, testimony is evidence. Mr. Smith did testify that the delivery that he was making with marijuana was taken from him, who we identified in the courtroom as a defendant, Turner. He brought to show first that the defendant took someone else's property. In this case, the property out of the possession of Mr. Smith was delivered to our house today. 2, that the defendant took the property without consent. Mr. Smith testified several times that he was there to deliver and provide the marijuana, but that he needed identification before delivering it. They say that the defendant and he did not consent to giving that property over until ID was provided, but was never provided. 3rd, that the defendant moved the property. It does not matter whether the defendant actually kept the property. In this case, the defendant did. The defendant kept the property and ran. 4th, that the defendant took the property from Mr. Smith's person. That person took it from his lap. The defendant took it from Mr. Smith's lap. And 5th, that at the time it was taken, the defendant intended to permanently deprive the owner of the property. In this case, the intent can be inferred from the defendant running and also never returning the property. So with that, Mr. Turner, I am going to have you bound over to 3rd Circuit Court for an arraignment on the information. You are out of custody, so it'll be 2 weeks from today. That will be May 8th at 9 o'clock, Frank Murphy Hall of Justice. Anything else? Attorney Cohen?
Sorry, Judge, I'm just checking with Mr. Turner on if there's any tether issues.
Okay.
Okay. No, no issues. Thank you, Your Honor.
And since it's bound over, as I stated before we began, if you want to amend the discovery order, you can send it today. I'll sign it before the clerk sends over the information, the package to the clerk.
Thank you, Your Honor.
Are good?
Yes, Your Honor.
Your Honor, would you mind,
Yes.
we have a waiver on O'Neill Walton if we jump in?
Sure.
Thank you.
Yes. After the waiver.
Yeah.
All these
under some stuff.
Where was that I do, I forgot it. Thank you, Officer Epps. Okay, ready on you, Walden? In this case, 2355595, the people of the state of Michigan versus Carly O'Neill Walden, charged with count 1, operating while intoxicated, causing serious injury. Count 2, operating license suspended, revoked, denied, causing serious injury. Temporary violations and appearances.
Good morning, I'm Daniela Parrish on behalf of the people, P85495.
Good morning, Neighborhood Defender Service by Kate Demont Grady, P83667, on behalf of Mr. Charlie Walden O'Neill, who is with us in the courtroom. Will you please state your name for the court?
Charlie Walden O'Neill.
Good morning. Today's the day set for the exam. I have before me a bind-over report. Is it correct that your client is going to waive his exam today?
Yes, Your Honor, I've spoken with Mr. Walden O'Neill about his right to a preliminary examination. At this point, the people would, if he held, move to add 2 counts of felony firearm. After speaking with Mr. Walden O'Neill about that, he is choosing to waive his preliminary examination and be bound over the circuit court.
Any objection from the people? No objection. Okay, Mr. O'Neill Walden, is that correct?
Yes.
What your client, what your attorney is saying?
Yes, Your Honor.
Okay. Did anyone force you or threaten you to waive your exam today?
No, Your Honor.
Did anyone promise you anything?
No, Your Honor.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over for your arraignment and information. It'll be 2 weeks from today since we were in custody, which will be May 8th at 9 o'clock, right where we all just, okay? Anything else?
Nothing from defense.
Thank you.
Thank you, Your Honor.
Still.
Attorney Diallo?
Oh, no. You're silly.
Sway boys?
Yes.
Okay, this is a walk-in for the case. Calling case 23055799602. People of Michigan versus Latoya. That Boyce charged with count 1, forgery of a document affecting real property, count 2, uttering and publishing as true documents listed in MCL 750.248B. Count 3, false pretenses, $1,000 or more, but less than $40,000, set for an arraignment, walk-in today.
And just a walking,
Judge, good morning to you and your staff. Lillian Diallo, Key 52036, on behalf of Latoya Boyce, who is a walk-in today. I will note, Judge, that there was a preliminary exam set for today at 11:30 that has been adjourned. So we would ask to arraign Ms. Boyce on this and set this over for the next, for PCC and then preliminary exam.
So we have an exam date set.
Okay.
What do that?
What date?
Your Honor, could there still be, because we are actually not the APAs on the case.
Sure.
And therefore, could you set both so that the other APA has a PCC so the subpoena can go out? Because we just set the exam and we won't, subpoenas won't end up going out.
So Judge, could you tell me what date the exam will be, the exam date?
May 8th at 11:30.
I'm starting a homicide trial on May 8th, but we'll work it out some kind of way.
Okay, so we'll have the PCC.
Yes.
That needs to be changed. It's, the APA is Latoya Willis.
Oh, okay. Sure.
Okay, so let's handle the arraignment first.
Wait for a reading of the complaint, I guess. Ask the court to enter, more.
Okay.
And ask the court to enter not guilty, please.
Okay, I will enter not guilty, please. Ms. Boyce.
Yes.
I'm allowing you to just walk in here today so that you do not have to go through the process again to be arraigned, okay? Because normally you have to go through the magistrate and get a date far out, but I am going to allow you to just come in today, your attorney working hard, you get your case resolved, okay?
Thank you, ma'am.
You're welcome. So I need you to show up for your next court date.
Oh, yes, ma'am.
Okay. So your exam is set, and it may change depending on availability of everyone. It's set for May 8th at 11:30 for in-person exam. Just how you came in person today, it's the same thing. I'm going to schedule a probable cause conference for both parties, Ms. Marshall and you. You just had an exam, her exam adjourned today, which actually works out. So today is the 24th. Can you do May 1st or 2nd, Attorney Diallo?
Yes, either day is good.
Let's do the 2nd.
Thank you.
And it'll be 8:30
Yes, ma'am.
on Zoom. You are to appear for that as well, but you are to be on Zoom. May 2nd at 8:30. And Ms. Marshall, prosecutor, Attorney Yellow, everyone will be on so we can move forward. However, it should.
Thank you so much, Mr. Bond.
Bond, it'll be 10,000 per person.
Okay.
Any objection from the people?
No objection, Your Honor.
You're welcome. You're having a good day.
You can wait outside.
Oh, and the bond condition also is, of course, no real estate transactions.
You hear that? Yes, ma'am. Right, thank you, Judge. All righty, and thank you for your consideration. It's wonderful supporting yourself. Hey, Rose.
Yes, ma'am.
I'm
Yes,
sorry.
everything. Kenny, Kenny, good.
What else say? Okay. The exam was set for today at 11:30. Yeah. So we said exam date, but now that we have, it is walking, I want to go together. Okay, thank you. Okay, I know you're ready, I'm good, but I'll have to.
I am ready, Your Honor.
All right, this is case. First of all, Madam Court Reporter, you need a moment? No. This is case 21-60929, the people of State of Michigan versus Yolanda Lola Good, who was charged as defendant 3 with count 3 controlled substance, manufacture cocaine, heroin, or another narcotic less than 50 grams. Comes with seconds or subsequent event notice, set for preliminary examination. Harrison?
Everyone to walk you CR438, appearing on behalf of people.
And good morning, Your Honor. May I please report Austin Gregory, GA5193, on behalf of Ms. Good, as the president of the courtroom. Ms. Good, please state your full name for the record.
Shalai Oda. Good morning, everybody. Thank you for your patience. Is everyone ready to proceed?
Yes, Your Honor.
Yes, Your Honor. Just a request for sequestration.
Okay. For the record, there's no one in the courtroom other than the necessary party, no OIC. Would there be an OIC on this case?
The OIC is.
You sure? Okay. If there's anyone on YouTube who may be watching or on Zoom who may be a potential witness, I'm moving forward. Now is the time to log off. Any other preliminary matters?
Yes, Your Honor. I have 2 exhibits under NPL 766.11. 1A, to put in Department of State Police Forensic Science division report that indicates that recovered was a heat seal plastic containing 2 folded paper packets. This tested positive for fentanyl. Exhibit 1. And exhibit 2 is a threat be entered under the same statute, MCL 766.11. 1.A. There's another Michigan State Forensic Science Division lab report, which indicated one heat sealed plastic evidence bag containing 4 folded paper packets, and this is positive for heroin, and fentanyl, and another tape steel plastic, heat steel plastic bag containing a 25 Ziploc bags, white material which tested positive for cocaine.
Okay, have you had an opportunity to review those documents?
I have, Your Honor. No objection for the purpose of preliminary.
Okay, and I believe it's 766.11B.
Yes, it is.
Would you like to publish those to the court?
Yes, I would.
So I will first say I will admit the letter.
Is that what you said? Okay, thank you, Your Honor.
May I approach you?
Sure. And you call your person.
We'll call Matthew Kaiser.
Or tell just what you're doing. Work with the front here, and when you sit down, you hold that microphone in your lap. So we can all hear you. Whenever you're ready.
Sir, could you state your name and occupation?
Yes, sir. Matthew Kaiser. I'm a detective trooper with the Michigan State Police.
How long have you been in Michigan State Police?
Over 27 years.
You belong to a special unit?
At the time of this incident, I was attached to the Combat Narcotics Task Force.
And what did it exactly do?
It's a narcotics investigative task force. The federal, state, local, and county officers. Multi-jurisdictional task force to target narcotics trafficking within the Metro Detroit area.
How long were you?
About 4 years.
Were you on duty on June 28th, 2021?
I was.
And were you on that date, were you at the location of 13570 Gallagher Street?
We executed a narcotics search warrant at that location.
Is that in the city of Detroit and County of Wayne?
It is.
What were you there?
We were executing a narcotics search warrant that we obtained as the culmination of several months of investigation.
And what did you, what occurred at that location?
There were several persons present in the location, with the defendant, Ms. Shalanda Good, being one of them. I know she's not seated with defense counsel, but I recognize her in the first row of the bleachers there, wearing a pink top with a gray fleece over it, glasses.
Record should reflect the identified defendant. What room was she in?
She was located in kind of a back kitchen area right off of the main living room when the entry team reached into the home. There was another defendant in that room as well.
What was his name?
Was Donald Lawson.
And on search, was anything found in it?
In that particular room, no. However, on Mrs. Good's person, she had 2 packets of suspected drugs concealed in her mouth.
When did you find, how did you come about finding that?
When we were speaking with her, you could tell there was something in her mouth. She opened her mouth and passed it. 2 packets that were later tested as fentanyl that were on her person.
Yes, Your Honor, how was you aware of this, how is it speculation? How is he aware of the location?
The location of what?
Anything.
The drug, her
Yes,
body
ma'am.
in the house or who's done?
Yes, but specifically drug.
I think I understand where that comes from. That's right. Clean it up. Did you search the defendant somehow?
I was present with a female trooper who was physically searching Ms. Good's person. And while speaking with her and trying to ascertain her name and who she was, tell there was something in her mouth. I was present when that was recovered out from.
Who actually, the female officer, pulled it out of her mouth?
The female officer pulled it out in my presence and handed it to me to be secured in that.
Could you describe what was in her mouth?
It was like a plastic sandwich baggie that had 2 folded paper lottery ticket type spindles containing a powder substance. As I previously stated, was later analyzed by our crime lab and tested as a fentanyl compound.
The test, Your Honor, this would be the test, exhibit 1, people's exhibit 1, is the test report related to these drugs.
Okay, can you clarify, you have 2 reports, I'm not sure which one you wanted, 1 or 2. Do you want to label them?
Yes.
All right, so you're referring to the 1-page laboratory report.
Correct.
As it admitted or was preliminary before the witness came on the stand that identifies the substance as fentanyl. Weighing 0.14656 grams. Is that what you're referring to?
Yes, Your Honor. Did you find anything else belonging to the defendant?
Yes, sir. Conducting a further search of the residence in compliance with the search warrant. In the main living room area of the home, there's a small table kind of tucked to the side near one of the corners of the room. On that table was a identification belonging to Michelle Good, as well as additional contraband items.
And what was the additional contraband items?
There were 25 individual prepackaged for sale and distribution packets of white chunky substance that was suspected to be crack cocaine, and that figure was in fact analyzed by our lab as cocaine.
Your Honor, that report will be, exhibit 2.
I have that.
Additionally, on that table, aside from the drugs, was new unused paraphernalia for the use of various narcotics, which is common in drug houses, so that users that come to the house purchase the drugs can also purchase supplies to then use those drugs, like syringes, Q-tips to use the cotton balls, which is used in the injection method of fentanyl.
Were those items at that house on the table?
They were all on that table, Your Honor. And associated paraphernalia.
And why is that amount?
Being as it was 25 individually packaged for sale and distribution amounts of cocaine, based on my training experience over 27 years, 4 years in a narcotics exclusive unit, that is indicative of a sale or possession with intent to distribute as opposed to a use. For the weight of the drugs, it would be cheaper for a user if they were to purchase in a single quantity, whereas when they break it down into individual drugs, it would become cost prohibitive for a user. That would indicate that this was a dealer quantity that they've already broken down to sell, which is the economics of the drug trade. By breaking it down is where the profit comes.
And the significant defendant's ID on that table? Is that?
The fact that her identification is literally linked with the drugs and the paraphernalia, in my opinion, indicates a possession or ownership.
Now, I think we're.
Your Honor, this is within his his realm of knowledge. He's a narcotics officer. He's seen these various times in his job, so he's the officer in charge. It is perfectly within his realm of knowledge. Know what this is significant for and what it means. You see this amount of drugs, an ID next to the paraphernalia.
It's important to clarify in his experience versus what happened on the date night.
I'm sorry, Your Honor.
It's important to make sure you clarify in his experience what he has seen or what is in his case.
Could you, I'm not.
Hello, officer.
Good morning, counsel.
So taking through this, you said that you found the defendant, my client, is good in the kitchen.
That's where she was taken into custody at the time of the entry team reaching the front door.
Okay, and you found in her possession 2 individually packaged bags of What do you think suspected?
On her person, there were 2 individual packets of fentanyl that was physically on her person.
Right, nothing else, right?
Not on her person.
Not on her person. But in a separate room, we find drugs, right?
It's an adjoining room, counsel. I'm sure your honor will be familiar with a typical Detroit home layout. When you enter in through a front door, there's some type of living room, foyer area, typically a kitchen right off of the back of that, and bedrooms off of the side of that. So it's an adjoining area, no farther than from me to the court officer separated her from the drugs at most.
Okay.
And for the record, what the council stipulated the distance of that feet from the witness to the court officer.
I would estimate around 15 feet, Your Honor. So there's 15 feet, there's another person in the kitchen with Ms. Good, is that correct?
That is correct.
And Ms. Good has 2 bags that you found, or that officers found in her mouth.
There were 2 bags on her person, yes.
On her person. Okay, so who was the owner of the house?
I believe it was, I don't remember if it was to the Land Bank of Detroit yet, or it was in some other third party that was not present at any point during this months-long investigation at the home. I don't recall the specifics.
Now, you said months long, you've been investigating who for months?
The primary target of this case was a gentleman, Ernest Cry.
Okay, so you were following Ernest Cry for months.
That's correct.
And did he demonstrate anything where you would, any signs of ownership of the home?
Yes, he did. To give an analogy for the board to help my response, in a corporate atmosphere, you would have a CEO, you would have a store manager, you would have other employees at a store. Mr. Cry was in charge of the operation. Ms. Good is believed to be one of the parties managing the house on the day-to-day operation.
So I'm glad you kind of pointed something like this out. So when you go through, you were providing surveillance for months, right?
That's correct.
How did you observe the there?
Ms. Good was observed on several occasions. One in particular, she was observed attending to the front door armor guard, and she unlocked it to allow other persons into the home that were believed to be customers, and then re-secured the door behind them, thereby demonstrating dominion and control over the entry to that home.
What date was this?
I would have to review some very extensive surveillance notes. It's all documented in my report and discovery.
And for the record, counsel, what is it that you handed?
I've handed the witness the investigative report, which contains no.
Judge, Your Honor, may take the work. I apologize, Your Honor. He's printed them on two sides, so it's a little hard to follow along.
Yes. Oh, okay. Yeah, because I would have started talking with them.
So I'm not sure if you have the page involved. Packets out of order. Locating it correctly.
Your Honor,
Yes.
would it be all right? I have a digital discovery here. This is all of the notes that-
I'd be happy to scroll through that if you
That's
want.
fine. Visual fine.
In order to scroll.
No,
No, Judge.
So you don't have to rush. I have a waiver to go on the record, so you take your time, stay right there and figure out the information.
Thank you, Your Honor. You don't have hundreds of feet.
I don't want you to feel rushed.
Yes, ma'am.
Okay, you can bring in Smith and then bring Smith and Robinson. You don't have to look at it. Stay right there.
Honestly, I was gonna go get yelled at by another judge.
Okay. Whatever me, I yelled, I said nothing. Mr. Schmidt? Okay, switching gears, we're on Stephen Lawrence Smith, case 2355918. People of the state of Michigan versus Stephen Lawrence Smith, charged with one count of weapons carrying concealed, set for a preliminary examination today. Appearances.
Daniela Parrish on behalf of the people, P85495.
Good morning, DeRay Elder, on behalf of Mr. Smith, my PIN number is 57728.
Mr. Smith, can you state your full name for the record, please?
Stephen Lawrence Smith, II.
Good morning. I have from the waiver form, is it correct your client is waiving his exam today?
Yes, Judge.
Any objections from the people?
No objections from the people, Your Honor.
And Mr. Smith, I'm going to ask you a series of questions. If you don't understand my questions, or if you can't hear me, just let me know, okay?
Okay.
Is it your wish to waive your preliminary exam today?
Yes.
I'll swear you, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Do you understand that you have a right to an exam?
Yes.
And that if you were to demand that exam today, the people will have to show at the probable cause standard, which is a much lower standard in criminal law, but still a standard, that that one charge I read off was committed in the city of Detroit and that you probably committed the crime. You understand that? And that by waiving your exam today, that means the people do not have to prove anything. Understand that? And knowing that information, you still wish to move forward.
Yes.
And waive your exam. Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Framework Hall of Justice for an arraignment on the information 2 weeks from today, so that will be May 8th at 9 o'clock. Anything else from you, Department?
No, Judge.
All right.
Good to see you. Thank you.
Good to see you. Good.
Okay.
I'm gonna have you on the. This is your number. Monte Watkins. Oh, this is Monte Watkins. All right, sure. All right, now this is Mr. Watkins, correct?
Yes.
Okay, this is case 2259045, the people of the state of Michigan versus Devontae Tyree Watkins, who is defendant number 1 and charged with count 1, robbery unarmed, and count 2, assault with intended to great bodily harm, less than murder or by strangulation, set for a preliminary examination stage. Appearances?
Good morning, Your Honor. Erin Dan for the people, P78733.
Good morning, Your Honor. Jabari Prempeh, P 81745, on behalf of Mr. Devontae Watkins, who is present to my right in the courtroom. Mr. Watkins, would you please state your name for the record?
Kevontae Tyree Watkins.
Morning. I have before me a waiver form. Is this correct? Your client is waiving today, Attorney Prempeh?
That is correct, Your Honor.
Any objection from the people?
No, Your Honor.
Okay, Mr. Watkins, I'm sure you were just listening. I'm going to ask you a series of questions. If you don't understand my questions or if you can't hear me, let me know, okay? And make sure you speak up for the court reporter. Okay? All right. Is it your wish to waive your exam today?
Yes.
You understand that you have a right to an exam?
Yes.
And that if you were to demand that exam today, the people will have to show at the probable cause standard, which is a much lower standard, still a standard in criminal law, that the charges I read off just a moment ago were committed in the city of Detroit and that you probably committed those crimes. You understand that? And that by waiving your exam today, that means that people do not have to show any evidence or prove any of that today. You understand that?
Yes.
And knowing that information, do you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over for the arraignment on the information, May 8th, 2 weeks from today, Frank Murphy Hall of Justice at 9:00 a.m. Okay? Anything else from either party?
Nothing on behalf of the people, Your Honor. Thank you.
Nothing on behalf of the defense. Thank you,
Okay,
Your
you
Honor.
want to the rest of your week?
You too.
Thank you. This is for.
Thank you, Your Honor.
Okay, we're back on the record. On Ms. Shalonda Good, and we will just wait until. Does it say a hold in it?
Very much.
Okay, we're back on the record on Ms. Good, and I believe Supervisor stated that he filed a report, correct?
Yes, ma'am. Again, I apologize. It was hundreds of pages. It's a months-long investigation. Very specifically in my surveillance notes dated 6/22 at 17:50 hours. It notates that a heavy-set black female led a subject into the home. That was my direct personal observation of Miss Good controlling access to that front door, as I previously testified. At that point, she was unidentified, so that's why she's only referenced as heavy-set black female.
Okay, now, you arrested a couple other people, and you noted where you noted a walkie-talkie in one person, and keys unlocking and locking, kind of like in another.
Question's a little, I'm not clear, counsel, but I believe I understand your intent. There were several subjects that were arrested and charges sought in this investigation. Again, it was a complex investigation.
Okay, and you stated, when you were talking about there were drugs found in the living room, which is approximately 15 feet away from where when the entry came in, they found this good. You stated that a person is cheaper to buy in a smaller quantity if you're an individual. That
No, perhaps you misunderstood my breakdown. Your Honor, if you were to, for example, purchase a 1 gram chunk of crack cocaine, street value is typically around $100. However, when you cut that up into tenths of a gram, those are usually sold for $20 a hit. So you've essentially doubled your money. So by breaking it down into the smaller increments to sell at a markup price, it would represent $200 in drugs if it were 10 individual packets versus 1 larger packet for $100, if that makes sense.
and you found 2 small bags on Ms. Good's person.
On her person, yes.
And
25.
And you found 25 bags 15 feet away.
Right
in a house with 2 other people?
With her identification, yes, sir.
I mean, right now, I'm away from a lot of things, right? Like,
certainly.
My bag is over there. Do I own this courtroom?
You still possess that bag, sir.
But do I own the courtroom? Do I own everything in the courtroom?
No, sir.
Okay, so a person's items can be somewhere in the house and they not own everything, right? Like if I put my phone over there on the desk, I don't own on the court reporter's desk. I don't own everything on that court reporter's desk, do I?
That's correct.
I'm not in control of everything on that court
Objection,
reporter's desk, right?
speculation. Response.
Your Honor, the officer's training experience is used and rely on to create analogies and to also create a circumstance of possession. We are getting into what he formed as is possession in terms of his interpretation.
I'll allow it. But as far as no, the definition of possession is very clear. That'll be given after testimony's done.
But I'm not in control of everything on the court reporter's desk, am I?
No, sir.
If my phone is over there or my ID is over there, I'm not. Am I?
That would be correct.
Okay. No further questions.
Redirect.
No, you don't.
Okay.
Thank you, ma'am. Thank you for your.
whenever you're ready.
People have no further,
Any from defense,
No, Your Honor.
whenever you're ready for argument.
people move for signed over on count 3 for the defendant, which is a controlled substance, delivery, manufacturer, cocaine, heroin, or another narcotics, grams, reserve argument.
Your Honor, very simply, the Miss Good did not have delivery. She was found with 2 small bags of usage in her possession in a house that she did not own, which was 15 feet away from her, and so the prosecution has not proven any intent to deliver or any actual delivery.
Well,
This is we have a probable cause standard here. The fact that her ID was discovered with or next to the 25 bags of drugs indicates constructive possession. Furthermore, she was observed by the witness unlocking the door, which gives her control of the premises. This is, as I said, is a probable cause standard, and there's not probable cause to indicate that she was working at delivering narcotics at that location. Again, this is, like I said, this is a probable cause standard. Those 2 facts alone, there's constructive possession of those drugs with her ID. Furthermore, she was found with drugs on her. It's indicated that she was delivering those drugs to customers. And we asked for a bind over.
And the court heard from one witness, Trooper Matthew Kaiser, who was very specific in his testimony. I won't recite the facts again, we all heard them. I think that people have met its burden of proof at the probable cause standard. This charge, one charge, the people had to show first that the defendant possessed the controlled substances, in this case, we ended up to be fentanyl and cocaine. The question here from defense is regarding not the 2 baggies of fentanyl found on the defendant, that was actual physical control and possession, but the 25 prepackets of cocaine found in the living room on the table with other paraphernalia used in Officer Kaiser's experience or Trooper Kaiser's experience to sell drugs with the defendant's ID on the table as well. I do believe that is enough to show that this, excuse me, Ms. Good did have possession at the time of right to control something that had knowledge of those substances, even though it was described as about 15 feet away. That satisfies count 2, which the defendant knew that she possessed a controlled substance. Third, that the defendant intended to deliver the controlled substance, as I stated, on the table in the attached living room. There are 25 packets of cocaine, syringes, cotton swabs, being described based on Trooper Kaiser's experience, described to with the intent to deliver the drugs. And fourth, that the controlled substance that the defendant intended to deliver, in this case, it was under 50 grams, so any amount that was identified would be sufficient. And I have exhibit 1 and 2 as entered under MCL 76611B1A for exam purposes only, that there were 0.1456 grams of fentanyl found on Ms. Good's person, as well as .1649 grams of heroin mixed with fentanyl and .1267 grams of cocaine. So with that, I will have Ms. Good bound over. Ms. Good, since you are not in custody, we'll have an arraignment on the information 2 weeks from today. That'll be May 8th at 9:00 a.m. Frank Murphy Hall of Justice. Anything else from either party?
No, Your Honor.
Okay, throughout the record on Ms. Good and your ears and.
Thank you, Your Honor. Thank you, Your Honor.
Okay, to Attorney Reagan, good morning.
Good morning, Your Honor. How are you this morning?
I'm all right, fighting a little cold. How are you doing?
Uh-oh, get better, Your Honor, get better.
Thank you. What is your client's name?
We have Mr. Juman Ahmad.
Can you spell that for us?
Jumon, last name is spelled Ahmed.
Okay.
We have a Bengali interpreter, Your Honor, that's present as well.
Okay. Interpreter is not present as of yet, is that right?
He was with us a few minutes ago, Judge, when we came over. I'm sorry. I thought he came with us. Hey.
Still sitting there.
That's the second. Why you checking?
Okay.
Okay, Mr. Zaman, good morning.
Good afternoon, Judge.
Okay, I'm ready to call Juman Ahmed, everybody. Okay, case 2305311, the people of the state of Michigan versus Juman Ahmed. Count 1, criminal sexual conduct, second degree personal injury. Count 2, criminal sexual conduct, assault with intent, sexual penetration. Count 3, criminal sexual conduct, fourth degree force or coercion. Set for a bond redetermination hearing today. Appearances.
Jennifer Douglas appearing on behalf of the people, P72748.
Your Honor, Philip Reagan on behalf of Mr. Ahmed, who speaks Bengali.
Judge, good afternoon, Syed Zaman, the Bangla interpreter for Mr. Ahmed.
In what language are you interpreting?
Judge is Bangla, Bangla. Bangla.
Bangla. Okay,
Yes,
I'm gonna
Judge, that's correct.
Mr. Zaman, do you swear to translate Bangla to English, English to Bangla to the best of your ability?
Yes, I do, Your Honor.
Okay. I will move slow so that you can have time to translate. Can you please have Mr. Ahmed say his name?
भाई आपने record होले अपना unmute करो का and अपना नाम होगा. When county jail need to unmute Mr. Ahmed.
Can deputy assist with the unmuting the device in the Wayne County Jail? Thank you.
From Your Honor.
Can you state your name, sir?
अपना नामटा होगा भाई.
আমার নাম হলো জুমন আহমদ।
My name is Jumon Ahmad.
Attorney Reagan, this is a bond redetermination hearing whenever you're ready.
Judge, Mr. Ahmad is 33 years of age with no prior criminal history.
You make sure you go slow enough with the interpreter.
Absolutely. Your
Excuse
Honor.
me. Judge, Janab Ahmad 33 বছর বয়স.
Judge, my client's 33 years old, no prior criminal history.
Judge, আমার মক্কেলর বয়স 33 বছর, তার অতীতর কোনো ক্রিমিনাল রেকর্ড নাই.
He has a wife and 3 kids with whom he lives with, and he supports fully.
Judge, তার বিবি আছেন এবং 3টা বাচ্চা আছেন যেটারে সাপোর্ট করে তারা একলগে থাকে.
In fact, Mr. Ahmad drives a Uber. He supports his entire family, Your Honor.
Judge, হে উবার গাড়ি চালায়, তার সম্পূর্ণ ফ্যামিলি হে একলা চালায়.
Judge, based on the fact he has no prior criminal history.
Judge, যে প্রতীয়মান যে তার অতীতর কোনো খারাপ রেকর্ড নাই.
He has a family which lives in the Metro Detroit area.
তার ফ্যামিলি লইয়া মেট্রো ডিট্রয়েট এরিয়া থাকে.
I am asking the court for GPS tether, house arrest.
আমি আদালতরে অনুরোধ করব যে জিপিএস টেটার দিয়া তার হাউস অ্যারেস্ট করিয়া রাখা হোক.
But because we are at the early stage of this case and there's no prior history of this nature, I'm asking for a high personal bond with those conditions.
আমি জাজ রিকমেন্ড করি হাই সর্বোচ্চ আপনার ব্যক্তিগত জামিনে তারে জিপিএস টেটার এবং হাউস অ্যারেস্ট দিয়া তারে মুক্তি দাও. আমরা খুব প্রাথমিক স্টেজও আছি কেসের.
Yes, Your Honor. We are asking that there be no change in the bond. This is a situation where there is some predatory behavior. We have the defendant who was working as a Lyft driver, driving 2 individuals, the victim and her friend. After the friend was dropped off and the vehicle got to the victim.
Douglas, he got an interpreter. He got an interpreter.
So,
I'm right.
Judge, it's okay, Jennifer. Judge, the driver, the Uber চালাইন একটা সিচুয়েশন, 2টা মানুষ এগুর in a way victim একটারে ড্রপ করিয়া আরেকটারে লইয়া দেওয়ার সময় এই ঘটনা ঘটছে.
When the vehicle got to a parking lot near the victim's residence.
এবং গাড়ি যে এগুর ভিক্টিম যে তার পার্কিং লটে গাড়ি ছিল.
The defendant got out of the car and opened the door.
প্রতিবাদী আপনার দরজা খুলিয়া হামাইছে গাড়ি ফিসে.
The victim stated they thought that the defendant was opening the door for them to get out. However,
বাদিয়ে মনে করছে যে আপনি ডোর খুলছো তারারে বদরতা হিসাবে বাড়াইবার লাগি বাদে দেখা গেল.
They forced their way into the back of the vehicle and began to assault the victim.
এবং তারে গাড়ির ফিসে ফালাইয়া তারে অবস্থার শিকার করা হইলো।
And Your Honor, this occurred after the defendant had multiple times asked the victim if she could come inside her residence, and she told him no.
ইগু কয়েকবার হইছে মানে জিজ্ঞাসাবাদ যে মানে ওর বা দিয়ে জিজ্ঞাসে তারে রেস্টুরেন্টে যাইতে পারেন ভিতরে যখন বা দিয়ে না করছে তখন এটা হইছে।
The victim stated that once inside the vehicle, the defendant forcefully held her down.
এবং বাদিয়ে কইছে যে তাই যখন প্রত্যক্ষান করতে যাইতো না এলাও করতো না গরো যাই নিতে তখন তাই জোর করিয়া তারে গাড়ি তাইরে ফালাইছে সিটো।
He grabbed her breast repeatedly and ripped her jacket.
তাই জোর করিয়া আপনার জবরদস্তি করছে।
He bit her repeatedly, first biting her breast.
তার দুধর মাঝে জাতা মারছে।
Then he straddled her and bit her lip.
তার তখন তার ঠুটোর মাঝে করছে।
And then he forced his hand down her pants, grabbed her penis and forcefully pulled it out.
এখন তার বাদে তাই ফোর্স করে তার প্যান্ট খুলিয়া তার বসই তার লজ্জাস্থানে ঢুকাইবার চেষ্টা করছে।
The defendant ended up getting off the victim and she was able to run to safety.
তার বাদে তার উপরত নড়ি গেছে এবং তাই ফালাইয়া যাইতে সক্ষম হইছে।
We have a situation where a person is in a position of trust. People trust their Lyft drivers or any other sort of commercial driving. He waited until he had her alone. He used force and Your Honor attacked her in multiple ways. And so Your Honor, we think that it is not appropriate for there to be a personal bond in this case.
Judge, এগু একটা মানুষের যে একটা বিশ্বাস লিফট বা ট্যাক্সি কেবল উপরে মানুষের উঠি দিব একটা বিশ্বাসঘাতকতা করছে আপনার এলা সিচুয়েশন করিয়া এখন কাস্টমার ওলা হেরাস করছে ভিকটিম করছে এবং আমি মনে করি না যে এটা সঠিক হইব তার ব্যক্তিগত জামিনে মুক্তি দেওয়া।
And I would point out that this is a situation where this ride was hailed using an app and the defendant was easily identifiable through that app.
এগু তাই অ্যাপের মাধ্যমে তারে পাইছে মনে রাইডর লাগি এবং ইজিলি তার আইডেন্টিফিকেশন পুল করা যাইব।
And knowing this, he still decided to do this.
But হে ওর বাদেও হে চুজ করছে একটা ওলা খারাপ কাজ করতে।
And so we're asking the court not to provide a personal bond for the defendant.
লাগি আমরা আদালত অনুরোধ করবো সবিনয় যে তারা ব্যক্তিগত জামিনে যেন মুক্তি না দেওয়া হয়।
Okay.
Judge, just one last note. You know, Judge, and I know that these are allegations and you know, the people say, you know, he decided to do this even though he had a picture of her and information, Judge, but just maybe it didn't happen the way in which the investigator's report reads, Judge, which is hearsay, which is not admissible, which is one side of the story. You know, Judge, I don't know if the court has a copy of the investigator's report.
জাজ আমি জানি না যে আমি একটা সংক্ষেপে একটা লাস্ট কথা হইতাম চাই এড করিয়া আমার সরকারি উকিলর উত্তর হিসাবে যে আমার বাদীর কথা যে বিবাদী হে জানা বাদে তার ফটো আছে চার্জ সিস্টেম তার ইনফরমেশন তার বাদে একটা উদ্দেশ্য প্রণোদিত হচ্ছে সজ্ঞান এটা করছে এটা শুধু জাজ একতরফা রিপোর্ট দেওয়া হয়েছে ইনভেস্টিগেশন রিপোর্ট এক-সাইডেড সো আপনার কাছে ইনভেস্টিগেশন রিপোর্ট আছে নি জাজ?
Judge, I would just renew my motion for a high personal bond.
Again, আমি জাজ আপনার সবিনয় বিনতি করবো যে তার ব্যক্তিগত জামিনে বেশি পয়সার ব্যক্তিগত জামিনে তারে বিশ্বাস ক্ষেত্রে তারে মুক্তি দেওয়া। আমি দুই পক্ষ শুনলাম
And Attorney Reagan, while you did state that the defendant does not have any criminal history,
এবং প্রতিবাদীর উকিল জনাব রেগান তুমি কইরা তার অতীতর কোনো ক্রিমিনাল কোনো হিস্ট্রি নাই।
there are other factors that I have to weigh in.
ইনো অন্যান্য আরো জিনিস আছে আমার এগুলা আবার দেখতে হইব।
Including the safety of the community.
সেফটি কমিউনিটির সেফটির ব্যাপারে আমার দেখতে হইব।
The seriousness of the charges.
এটা খুব খারাপ চার্জ অভিযোগ।
And the likelihood of conviction.
এবং যে একটা তারপরে লাগানো হয়েছে।
And I know that Attorney Reagan stated that he has ties with his family and the community in the state residence.
রেগান উকিল রেগানে কইছেন যে ডিট্রয়েটে বসবাস করে তার ফ্যামিলি লইয়া।
But based off of what APA Douglas has provided to the court, I am not going to change the bond.
এর লাগি আমি তা সপ্তাহ পরীক্ষা করাইয়া আমি একটাও আমার সিদ্ধান্ত যে আমি বন্ড চেঞ্জ করতাম না।
Thank you very much, Ronick. Judge, can I ask the court at this stage, when the court says the likelihood of conviction, what does the court mean by that?
Well, APA Douglas, oh, sorry, go ahead.
আমি আদালতের সবিনয়টা জানতাম চাই যখন আপনি কইরা এগু খুব সম্ভব হইলা গড়ছে বা ওটা এটা বলতে তুমি কিতা বুঝাই রে জাজ?
APA Douglas spoke of the app where the defendant is identifiable.
যেহেতু এরপর মাঝে প্রতিবাদী হে তার পরিচয় আছে সিস্টেমও।
And the only reason I say that, Judge, is because, you know, we're still early. I don't know what other stories will come out. I don't know. My client hasn't had his opportunity to tell his side of what happened. We're hearing it from one side. So a lot could come out later, Judge, but I appreciate the court's indulgence. Thank you for your consideration, Judge, for bond.
Judge, এগু একতরফা হুনা হইলো আমার মক্কেলে তার তরফা তার সাইড তো করার কোনো সুযোগ নাই। আর তার মাধ্যমে আদালতে আমি অ্যাপ্রিশিয়েট করি আপনি একটা সিদ্ধান্ত দিছেন।
Like a DSU report order?
Please, Judge. Thank you so much, Your Honor.
আমি কোর্ট অর্ডারটা আমার দিলে অ্যাপ্রিশিয়েট করব।
Anything from the people, Ms. Douglas?
Nothing further, Your Honor. Thank you, Your Honor.
Okay.
জনাব ডাগলাস আপনার কিছু খাওয়াছেন না আমার কিছু করার নাই।
Judge, you and your staff have a wonderful day. Take care. Thank you so much.
জাস্ট আপনাকে শুভ দিন কামনা করছি।
Okay, we are on the record.
Bye, everyone.
Hi, Judge. Thank you. All right.